it would appear that we're going to have approximately 80 people on the webinar, which is larger than our normal class that we have at the association's offices. Also, I'm going to do this a little bit differently than perhaps some other Zoom conference calls that you've had in the past. The traditional format is that most presenters in webinars attempt to just engage in a directed conversation to the people listening in on the webinar and not entertain questions during the presentation. I'm going to change that up. I want this webinar to be more of a exchange of information where you're asking questions, and I can do that in real time based on the data that we have in front of us. But in addition to that, just for those of you who are not used to a Zoom type of webinar call, at the bottom of the screen, if you move your cursor down, you can see where you can enter a question using the chat function. Rather than you unmuting your microphone and asking a question verbally, because again, we're going to have approximately 80 people on the call, I'd rather you use the chat function. I've got two of my assistants, both Maria and Angela, that are going to be assisting me. And if I bypass your question and they see that it's a question that could be really beneficial for everyone's benefit, they're in an adjacent room and they'll bring that question in. But I'm going to attempt to watch the chat function as we go along. And Christina, thank you very much for your first chat comment, which was, yay, I'm pumped for any Rick Snyder class. So that's good feedback for Shirley and for me, and I appreciate that very much. Additionally, I want you to know that from the flyer that was sent out by Shirley for the association, we talked about it being 1482 and a property manager's or property management perspective of COVID-19. You'll note in the slide presentation that I have that we're going to go through, that if you've taken this class recently, it's going to be the same PowerPoint presentation, but I'm going to seek, much like an improv, to interject in the context of the call elements of COVID-19 that have impacted on 1482. This environment is so dynamic and so fluid that the situation that we find ourselves now in is changing almost on an hourly basis. I was just off a call with both one client and another peer that's in the same size company that I have, that we're continuing to exchange information because this environment is changing so rapidly, and I'll talk about that as we go along. Also, as a preface to the webinar as we go through, I also wanted to talk about COVID-19 and its impact. And again, I'm going to interdisperse some information through the presentation. But one of the things that I want you to start thinking about is that we're in an environment that 1482 was enacted under in what I'm going to describe as the pre-COVID environment. And so we saw during that, what I'm describing as the pre-COVID environment, so this is the period in December and before, and even into January, where there were a number of legislative initiatives like 1482 that were significantly impacting the rental housing industry. Now, in the environment from mid-January to where we are now, mid-April, we continue to be in the COVID environment, what I'm describing as the COVID environment. And then as we start reopening the economy, we're going to go into what I'm going to be describing as post-COVID environment. And one of the things that I've kind of adopted, and I want you to adopt as well, I would urge you to adopt, is that in the post-COVID environment, what we knew as the rules of engagement and the way in which we were operating in society in general, and in the rental housing industry, we're not going to return to a pre-COVID environment. The new operating environment that we're going to be experiencing, the post-COVID environment, is going to have some rules of engagement that are significantly going to change the way that we're interacting. As an example, there's been discussions through the Dr. Fauci and the CDC that social distancing, such as eliminating handshakes, is something that's going to be a hallmark of the post-COVID environment, even when we start getting back to normal. The social distancing is likely going to be in that same context. Even the issues relating to maintenance calls, where a maintenance person is going to be called into an existing apartment, is going to be different. I can imagine a situation where the maintenance technicians or third-party contractors are going to be wearing gloves, and they may or may not wear masks, but they're going to be cleaning the area in which they're going to be working. They're going to be replacing the faucet, as an example, and then they're going to be cleaning and disinfecting the area once again. And I think that this is just part of the dynamics, and that's just an example of the kinds of things that we're going to be experiencing in a post-COVID environment. And because this situation is changing so dynamically, I'm anticipating that because it is fluid, that we're going to continue experiencing changes unlike anything that we've ever seen. And that brings me to the next point. I thought, for those of you who have not taken one of my classes before, I've been in the industry since 1974, so for a very long time. I got my real estate license, started management when I was a senior in high school. I thought that I had seen just about everything, but then this COVID environment has significantly changed everything. And I think it's going to change, as I've said, our world going into the future. My company manages about 6,000 units in Southern California, primarily in San Diego County. And so we've got a breadth of experience and reach that we experience in multiple properties and multiple communities across San Diego. And we've been at the forefront, and I have as an individual, both within the local association at North San Diego, but also through the apartment associations locally, through SoCal RHA, the Cal RHA, the state organization, and the National Apartment Association. I also want to recognize that for the purposes of this discussion, that many of you are operating smaller properties. Some of you, based on the surveys that I've done with various people, have indicated that they're managing just single-family homes or less than 4 units. That while there's some people that are involved in managing commercial properties, it's the vast minority. The majority of people are engaged in managing smaller properties. And there's a smattering of people that are involved with having properties that they have an on-site resident manager. But I'm going to be seeking to direct my comments to the environment associated with smaller properties as opposed to larger ones. But again, if you've got a question relating to other non-small property types, then feel free to put a question in on chat, and I'll go ahead and recognize that question if it fits within the context of the discussion that we're having. Let me also make one more prefacing comment about the disparate impact of COVID-19 on property types. based on anecdotal information that I'm receiving, we're seeing that March, through effective communication with our residents, and again, I'll get into this at the end of the conversation or the webinar, we've been largely successful in encouraging most tenants to pay rent. My sense is that the majority of tenants are operating in good faith. We've given them and provided them with resources that they could get the stimulus money, which has generally been received since April 15th. We've also provided them with resources if they've lost their job to be able to get unemployment insurance, which the normal 1 week delay period has been waived. And instead of getting 60 to 70% of the unemployment that would normally be received under unemployment insurance, it's been increased to 100%. And many of those checks are starting to be received. We had one case where a prospective tenant was asking to move in to one of our communities and was using their rent for income, their unemployment check, which based on what the tenant said to us, a prospective tenant, that they're actually making more money under unemployment than they would have in a traditional environment, given all the circumstances surrounding it. And sometimes that's what occurs. Now, in the context of all of this, though, multifamily, including single family homes, have generally been weathering the storm very, very well so far. Senior projects have been doing extremely well. Section 8 tenants, those tenancies have been doing very well as well. Senior complexes, because they're on fixed incomes, have also been doing very well, especially with Social Security. What we are finding is that office building space and retail is getting hit hard. Retail and many of the complexes that we're managing, the income being collected for the month of March was only 50% of what we would normally anticipate or experience in a typical environment. So that's going to be continuing to be challenging, and we anticipate that office space, the footprint that has been traditionally viewed as required for a given business, is likely over the next couple, 3 years to retract. That tenants are going to see what is critical and what is not critical, and that they will be finding that they're in a situation where it's going to be much more problematic. Now, there was a question that came in under chat regarding resources to the tenants. I can send out to you, if you go on to the governor's website, that's one quick source, you'll find that there are excellent links to the resources that I just identified. Also, one person that let's see, there was one. There's another one. Somebody suggested findhelp.org is another recommendation for resources. There are tremendous resources. Even the governor set up for individuals that were not eligible for the stimulus because they may be here as undocumented aliens, but were operating in our economy. The governor set up an ability for, or a portion of the budget of $10 million to provide the equivalent of the stimulus money and to assist tenants that were, if you will, falling through the cracks. And so the amount of resources going on both at the local, state, and national level are significant under this crisis that we're experiencing. So with that, let me go ahead and move on to 1482. So on just cause, which is part of 1482 and also a part of the city of San Diego's ordinance, is effective at 12 months of tenancy. If any of the adults are added to the rental agreement before the existing tenant has occupied the unit for 24 consecutive months, then one of the following must be satisfied. All of the tenants have occupied the unit for 12 months or more, or one or more of the tenants have continuously occupied the unit for 24 months. Now, just cause is for just cause eviction. So let me interject just at this junction regarding the governor's order, which you'll see at the end of the PowerPoint presentation, that indicated that there can be no evictions regarding failure to pay rent, given the COVID environment, through May 31. Now, that's since been extended. And I should mention to you that the courts are not handling unlawful detainer actions right now. We're in a situation where through additional governmental actions that have occurred, it's anticipated but not certain that the courts will, for civil cases, will reopen on March 31. I'm sorry, May 31. But there is a moratorium. I was going to say a prohibition, but moratorium is a better term, that is going to extend for an additional 90-day period from the courts reopening. So it really puts us out to September for any unlawful detainer actions in terms of the processing. That has created a lot of issues with a lot of misunderstandings and because of some of the communications that have gone on in social media regarding that issue. It's important to note for all of you that while there is the moratorium on eviction, it does not provide a moratorium for tenants not to pay their rent. Although there is a legislative initiative, AB 828, I believe, that has passed the Assembly that could affect that dynamic. Now, whether it's going to be passed by the Senate or it's going to be signed by the governor is a different issue. But there are both initiatives at the state level as well as the national level attempting to address and deal with the issues surrounding the ability for tenants to pay rent and having some type of rent abatements. There is a significant effort within the city of San Jose right now to waive rent for April, May, and June in San Jose. There's an effort in the city of New York as well. And so all of these initiatives contribute to the lack of cohesive information that is providing clarity to tenants relating to their responsibilities under payment of rent. But let me just summarize by saying that it is important to recognize that tenants do have a responsibility to pay rent, but there's some issues surround notice that I will get into in a little bit. So within the just cause, and this has to do with no relocation payments, there is both an at-fault cause and there is a no-fault cause, which requires a relocation payment. So in this context, let me put this in the context of what those requirements are. So no relocation payment is required for a non-payment of rent, a breach or violation of the rental agreement. If the violation is curable, the landlord must first give the tenant an opportunity to cure the violation. If after that time period set forth, the violation is not cured, a landlord may issue a 3-day notice to pay rent or quit. So let me stop there and just talk about that as an issue. It's clear in the governor's order that 3-day notice to pay rent should not be issued. There is an ongoing concern or issue that the landlords may seek to, in the governor's order, to intimidate residents in their payment of rent. And so it is my urging that 3-day notices to pay rent or quit not be issued, but rather a letter of communication be provided to the tenant in order to encourage them and have them recognize that they still need to pay rent. But we're seeking to provide them with the resources, and we're seeking to assist them during this crisis period of time. Now, this is a policy that we're taking that you may want to consider, is that we are not imposing any late charges on rent. But we, again, are indicating to residents that it is to their benefit to pay rent. And we've actually had tenants paying their rent in advance because they don't want to have to be concerned about it. We've also entered into hardship agreements, which you'll see at the end of the presentation, that the California Association of Realtors has created in order to assist both in terms of the communication, and again, I'll show this to you later, as well as an agreement, a hardship agreement regarding their payment of rent. But I would not issue any 3-day notices to quit. Now, regarding committing or permitting a nuisance or having criminal activity, in those contexts, on an emergency order, the court is allowing those to be heard, but based on my experience, that would be only on a situation where you have an extreme situation. Even situations where tenants, based on my experience, where tenants have been arrested for creating a nuisance or creating a criminal act in the property, that is not being heard by the courts at this time. And the unfortunate part is that our residents are the ones that end up finding themselves in the position at the effect of this tenant who is creating a nuisance. But unfortunately, in this current situation, this is an environment that we're dealing with, and we're going to have to do the best that we can given the circumstances. I have heard of instances where landlords are seeking to work out some type of settlement with a disturbing tenant as a means or a way to encourage that resident that is creating a problem in the complex to vacate. And as unpalatable as it may sound, it's in the context of cash for keys, just to be clear. And it's not something that I would encourage you to do, but in a situation where you have tenants that are saying, you know, this situation is intolerable, I can't deal with it any longer, and I'm going to move out, and you're faced with that kind of situation, you may want to consider that type of action. So there's also a refusal to allow an owner to come into the unit. Now, this is another interesting dynamic that is occurring because of the COVID-19 environment. Our number of maintenance requests that we're experiencing at projects have significantly decreased. You may have heard on the news that the government, indicated that they were telling or directing hospitals to eliminate elective surgeries in order to increase the bed space for COVID-19 patients. What's happened, though, is the number of urgent care appointments and emergency room appointments have significantly dropped because the general population don't want to expose themselves to COVID-19 that they view as a potential of going in and seeking hospital care. So as a result of that, hospitals are actually having to lay off people even doctors and nurses because they've got excess capacity. In the same way as people are not going in for medical care, we're also experiencing that tenants are refusing to go in, allow us to go in to do work on a unit. So we're taking the position that as long as it is not an emergency and is not negatively affecting the unit or adjacent units, that we're not demanding to go in on an emergency basis. Tenants just don't want us to go in, and I completely understand that. But as a result of that, many of our maintenance personnel are working on exterior units as opposed to going into the units. Now, in our case, and I've discussed this in other classes, it's not been unusual for us, and it's been part of our procedures over the last, say, 10 years, to do inspections on the interiors of the units every 6 months. So we do what we call our spring inspection and our fall inspection. Because of the COVID-19 situation, we have elected not to do our spring inspection. We're adhering to the social distancing guidelines, and we're recognizing that many of our tenants are not going to want us to come into the unit. So we're going to go ahead and do that. Now, there was a question that came up regarding AB 828 and that it has gone over to the Senate. So I'm circling back on that particular issue. As it relates to the Assembly passing that 828 bill, it's going over to the Senate Housing Committee, I believe, and it's not scheduled for a hearing to my knowledge. So I have no knowledge when it's going to be heard either in that committee or in the general Senate. But given the fast tracking of some of this legislation that is going on, I think you can anticipate that within the next 3 to 6 months, we're likely going to see something along those lines. Now, one of the things that is not generally known regarding the application of 1482 is that a resident manager is exempted from 1482. So that if you want to have a resident manager who you are terminating for cause at your complex, and again, most of you don't have resident managers, but I just want to put this in context, then there's no relocation payment required for a resident manager. And the last bullet point is when a tenant is given notice to vacate but then does not surrender the possession. So this is a situation where you're not giving the notice to the tenant, but the tenant has given you notice. And again, those notices should always be in writing. In that particular case, when the tenant has given notice and said that they're going to move out, say on the 30th, but doesn't, then you could seek to terminate tenancy with no relocation payment that is required. So then in the context of no fault cause requires relocation payments. So if you're an owner occupancy or occupancy by, you want to create an owner occupancy, you can do so. But in that case, you need to be able to provide the relocation payment. If you're going to withdraw the property from the rental market, that would also require a relocation payment. If you're complying with a governmental court order relating to the vacating of the property, that's also a requirement for a relocation, or there's an intent to demolish or remodel the property, which I'll get into in a moment. You probably have seen throughout San Diego County, but especially in say the North Park, Hillcrest, and other areas within the city, that there's been quite a bit of demolition of older properties and building up of new properties because of the increased density ability that has been granted both by the state and by the local governments. So you're seeing more properties being demolished. That then triggers the relocation payments. Now, I did get a question about what is 828. I don't have the specific provisions, but if you, in front of me, and I don't want to misquote them, but if you put in on your, like you Google the information, put California AB 828, you can get the actual bill language so that you can take a look at that. So then let me go to the next screen. So on the substantial remodel is defined as the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency or abatement of hazardous materials, including lead-based paint, mold, asbestos, in accordance with applicable federal, state, and local laws. And you can read the balance of this. Now, the most important part is the last section, which is cosmetic improvements alone, including painting, decorating, and minor repairs or other work that can be performed safely without having the residential real property vacated, do not qualify as substantial rehabilitation. There was a view at one time that the substantial remodeling would give an ability for a landlord to provide notice to terminate tenancy in order to rehabilitate the particular unit. And it's generally been viewed since the passage of 1482 that that is not the case. But if there's a permit, and you can see that where the vacating of the residential real property for at least 30 days, so that is, as an example, if you have a problem that has occurred where you have to repipe the property, you're going to obtain a permit for that purpose. Or alternatively, that you have lead-based paint, you need to do an abatement or mold or asbestos, where it hits that you're getting a permit and that the work is going to take over 30 days, then that hits to the standard of a substantial remodel. And you may want to utilize this provision in order to undertake and complete that work. Because one of the issues with the substantial remodel, where you're giving notice for cause under this substantial remodel, actually it provides you with the ability to have that tenant move out, and under the current statutes, bring the rent up to the current rent level or the market rent level for the project. So now let's get into relocation payments themselves. The relocation payments require the relocation is no fault, requires the relocation payments rent of waiving, either providing 1 month's rent or waiving of the last month's rent. And this is an important provision because any notice must contain the information that the tenant has the right to relocation or waiving of the last month's rent. And this is the interesting provision that was put in 1482, is that any relocation payment must be provided to the tenant within 15 days of the notice. So that, let me give you a perfect example. You give a tenant a 30 days notice for where there's a relocation payment required, that when you give them that notice, within 15 days, you have to provide them with the relocation payment. One of the things that often comes up in that context is that we are in a situation with that, that payment that a tenant could simply not leave, and then you would still have already paid the money. And the statute unfortunately provides that you have to go after the tenant, which is going to be very problematic and difficult. If the tenant does not vacate after the expiration of the notice, then the relocation or waived amount shall be recoverable as damages in an action to recover possession. But again, that's always difficult. And the question came in, wouldn't that be a 60 days notice? And it would be under current statutes. That's exactly right. So it's not just 30 days, it would be 60 days. And if the owner does not comply with the requirements in this law, the termination notice will be void. So it is not only giving the proper notice, in this case a 60-day notice, but it's also an issue where you have to, within 15 days of the notice, not only provide the payment, but do the notice properly. And this is where, again, if you've taken my class before, unfortunately, this entire environment is becoming increasingly more complex. And for someone who is not invested on an ongoing basis, keeping up with this dynamic and fluid environment is going to be really difficult. Now, as it relates to the relocation payments, this is something that is being initiated by the tenant. Let me get into, and then I'll talk about tenants where they're giving the notice. The city of San Diego, as I've mentioned, the existing just cause ordinance remains in effect. It does not apply to tourist hotel occupancy. It does not apply to nonprofit or religious facilities or residential care facilities. It doesn't apply to dormitories for school, as an example. And it does not apply to accommodations in which there's a sharing of a bathroom or a kitchen, like an SRO or single room occupancy type of tenancy. And the exemptions also include single family owner occupied residences, including a residence in which the owner is occupying one of the units where there's 2 units or bedrooms, or a duplex, as an example. It also, and this is one of the carve-outs, it does not, 1482 does not apply to properties that have been built where a certificate of occupancy has been received within the previous 15 years. So this will be a rolling date as we move through. And there is the single family homes or condos are part of the exemptions as long as they're not owned by a real estate investment trust or a corporation or a limited liability company in which one of the members is a corporation. Now, one of the questions that comes out in this context is, what if I have an LLC? As long as the limited liability corporation is solely owned and is a corporation is not part of that limited liability company, then you still have the exemption where it's a single family home or condo. Let me see, there is a question that says, couldn't you just give the tenant the 60 days notice with the notice that waiving of the final month's rent will be done, and will be done with it right then and there? You possibly could. But the key element within this provision that they're attempting to get to is that they want to make sure that the tenant has the financial capability to relocate if the owner initiates notice to terminate tenancy. And effective July 1, 2020, the prescribed language must be provided in the rental agreement. Now, in my particular case, one of the things that we have done is January 1, we put out the new language. Now, the California Association of Realtors, if you use that agreement, they came out with the revised document for the lease. that has the new prescribed language regarding 1482. We've taken it upon ourselves in the context of the problems that we're seeing with this fluid environment, that we're updating and providing new leases to our tenants on an annual basis. And we're doing that usually in January and February when the new lease documents come up. There was also a question. I've mailed the notice of exemption to one of my tenants back in December of 2019, but they've never signed or returned. Are they all exempt from 1482? I'm not going to provide legal opinions, but what I've done is said to the tenant, this is the new lease terms and conditions that I'm providing pursuant to the notice of the new lease language. And whether I get the document back signed, it is the document, because I've provided proper notice, that I'm using and that provide the boundaries of the terms and conditions of the lease between myself as the landlord and that tenant. So I'm not so concerned. It would be beneficial to get the tenant to sign it, but as long as I can identify that I've given them proper notice, then that's what I'm going to be operating off of. So let's get into rent caps, which is kind of an interesting topic in the context of COVID-19. So when you read this, the rent caps at 5% plus the cost of living as measured by the Consumer Price Index for all rent increases occurring on or after March 15th, 2019. One of the things that I want you to recognize is that it says annual rent increases. Now, you'll see in a couple slides further that when I get into this, that I had indicated that the increase based on the best available information at the time was that the increase of the San Diego CPI was 2.2%. That has now, if you go on to and you do a Google search and you put in Consumer Price Index for San Diego, and you'll see that the information for March 15th that just came out on April 10th indicates that the cost of living for San Diego was 1.8%. So the numbers that we previously were using of 2.2% have been modified. And there was a note, if you Google it and you get the document, and I just got this information yesterday, which is why it's not included in your PowerPoint presentation. That's how fluid this environment is. That where the general industry information, that our best estimate of what the Consumer Price Index was going to be of 2.2% has actually been reflected as 1.8. And in their technical notes, part of it is based on their surveying, but part of it also is as a result of, this is my view, as a result of the Consumer Price Index being affected by COVID-19, recognizing that our economy started shutting down in February and then also in March. There's a couple of questions on exemption. If you are renting a single family unit or a condo and are not a REIT, LLC or corporation, are you exempt? The answer is yes, based on the exemptions that we've got. There's also a question, what happens when the owner wants to get the property back to rent to someone else or to sell when the lease is up? Then in that particular case, the just cause eviction, it comes into play both in the, if it's City of San Diego, but also at the state level. And my recommendation in this environment is that you need to be able to get legal advice. I don't want to provide any advice on that particular issue because this environment is so problematic. I would say it's fair to say that in this current environment, that providing a notice to terminate tenancy would be very problematic. How's that for being diplomatic? And I think that quite a few tenants are going to be resistant to be willing to move out in the current environment or to go seek to find a new property. So another question is, so the new 1.8 is retroactive to 2019, or is this the new number for 2020? So there was a provision that required us, if we had increased rent over the 5% plus CPI, to roll back rents in January of 2020. Many of us who had increased rents over the what we viewed as the 7.2% rate did roll back rents on January 1. I just got this information yesterday, so we're in the process of reviewing this situation. But it was recognized that we were not going to know with certainty what that cost of living increase number was going to be, even though we were required to reduce our rent if we had exceeded at that time what we viewed as the cost of the 5% plus cost of living. So we made a best estimate based on that number. And if you remember back with the implementation of 1482, they wanted to make sure that rents were not going to be increased as a result of the passage of 1482. And so what they did is that they went back and said all of these applicable statute elements are going to go back to March 15th of 2019. But if you looked at an annual cost of living increase, at the time that this was passed, I believe in November or December of 2019, we didn't know, and we wouldn't know, what the March 15th, 2020 cost of living increase would actually be on an annualized basis. So we're being caught, if you will, in this application of the new law as it relates to the process of, in a good faith effort to comply with 1482. So this is again one of those COVID-19 problem elements, if you will. So let me go on to the next slide. And this is what we were just talking about. If a landlord increases rent by more than this cap between March 15th and January 1, the rent on January 1 must be rolled back to what the rent was on March 15th, which would be that amount plus 5% plus CPI. Now, the landlord does not have to pay the rent back or credit the tenant for the excess that was paid prior to January 1, 2020. Landlords, and this is a little bit more of a complication, but again, even in this formula that I have in the third bullet, based on what was being used in the industry at the time, you can see what we were using. So the first section, the first bullet, landlords who increase the rent by less than 5% plus CPI between March 15th, 2019 and January 1, 2020 may increase the rent twice within the 12 months of March 15th, 2019, but not more than the 5% plus CPI. So then let's get into the second bullet. A landlord who increased the rent by more than the cap between March 15, 2019 and January 1, 2020, and who was then required to roll the rent back to the maximum increase allowed by the cap would need to wait until the anniversary of the last rent increase to increase the rent the maximum allowed by the cap. Hence where this gets more complicated. And then I used an example in the last bullet, which is using the current regional CPI, the landlord raised the rent 5% in June of 2019, and then another 3% in October of 2019, exceeding the cap via the second increase. The landlord will need to roll the rent back 0.8% on January 1. If the landlord wants to do one increase of the maximum allowed by the cap, 7.2 in the previous example, in 2020 would need to wait until October to do the increase. Alternatively, would increase 5% in May of 2020 and 2.2 in October of 2020. So now, all of this worked when I did this class some 3 months ago. So now let's talk about the real world. The real world is in this environment. The reality is that we're not going to be seeing rent increases in the near term, in my opinion. Now, is there an ability if a tenant vacates and you're improving the property and you're re-renting at market to a new tenant, that there's an opportunity for a rent increase? The answer is yes. In the current environment, based on what I'm experiencing, tenants are very fearful about the current environment and moving forward. In that context, we have found that tenants, because they've lost their job, and we've got, I think, 1/5 of the economy, of people in the economy have lost their job and are unemployment. So we're in a very difficult situation where rent increases are likely not going to occur. But in addition to that, based on our pulse on the market, we're seeing increases in concessions in order to drive and increase traffic and interest in properties. And we're also seeing where, in an effort to increase the marketability of the property, that landlords are not being as aggressive as they were on new rent levels for attracting new tenants. So again, in my context and in my world and that of my peers, and through this webinar and providing this information to you, my sense is that rents are not going to increase in the near term, especially as to current tenants. And your guess is as good as mine as to what the next 6 months, 12 months, 18 months are going to look like. And maybe I should pause for just a moment and indicate to you, based on my involvement at the national level in the apartment industry and generally, that many economists, when they're talking to them about what this recovery looks like, originally they were hoping, this was when we were in the February period, that we were going to be experiencing a V. So we're going to see a sharp decline in economic activity, and then we were going to see a sharp bottom and a sharp recovery. Then there was a view that that we may be experiencing a U-shaped economic recovery, where we're going to see a sharp decline, which we've already experienced, and then as we would see in the bottom of a U, a number of months where we're going to experience difficult economic environments, and then perhaps a sharp recovery. There are a third level of economic views that it's going to be more like the Nike swish or the check mark, where we're going to see this steep decline and then a gradual recovery, which was characterized in the 2008, 9, and 10 economic recession that we experienced. But because we are in an environment where we don't have benchmarks that we would normally rely upon for both how we operate in this current environment, but also how we're going to expect this environment to act and how we're going to respond as we move out in time. There was also a discussion when we knew that there was the shutdown of the economy that there was a significant concern regarding the payment of rents in April. And we had typically a very good month in March, but there was deep concern regarding April. Those deep concerns were not generally realized, as I mentioned earlier, in April. We actually did fairly well. I'm cautiously optimistic for May because the stimulus money has hit, and also we have the issue of the unemployment insurance. So I'm cautiously optimistic of where we are and where we're going. Now, there's a question that came in. I've been contacted by commercial real estate brokers suggesting that there is a AB circulating within the California Assembly that suggests a 25% reduction of rents. Any comments? That is accurate. There is a bill being sponsored by, of all entities, the California Apartment Association, which I'm not affiliated with, that is sponsoring a bill. But the key element of that bill, and I believe it's an 80-20, not a 25%, but it is an assembly bill that is being sponsored by the California Apartment Association, saying that that landlords would agree to a 20% reduction in rent if the state government is willing to pay 80% of the rent for tenants that are affected by COVID-19. I was, and this is my own personal view, I was astounded that the California Apartment Association would sponsor such a bill. I felt that it was inappropriate. One of the things that's characterizing in this environment is that when they come up with these legislative remedies at the state level, they're extending that all properties are the same, that all geographic locations are the same, that all urban and rural communities are the same. And I just disagree with that concept. To impose this type of request or requirement legislatively, I think if I was being very diplomatic, I would suggest that it was very misguided. And there has already been significant pushback from a number of different elements of the rental housing industry regarding this proposal. But in this environment, as we did with AB 828, we're going to see a lot of legislative initiatives that are going to be going forward. There was a question going back to giving notice, properties is extended. CAR's form RCIC requires tenant signature as acknowledgement of the exemption and agreeing with the clauses for election. If the tenant doesn't sign, doesn't agree, would that form be valid only with the owner's signature, assuming the tenant has been notified? Again, a very, very good question, but I'm going to sidestep it a little bit because I'm not an attorney. Although, as many of you know, I do a lot of expert witness work, but I can't give legal advice as to the enforceability of the agreement where the tenant does not sign. I will tell you, I'm taking the position that if I provide them with proper notice and that I can identify that I have provided them with proper notice, that this is the document that I'm utilizing and that I provided them with proper notice, that's what I'm going to be operating from. But again, I would recommend that you seek legal advice regarding any enforceability issues that you may have or concerns that you have regarding the notice. So vacancy decontrol. For a new tenancy in which no tenant from the prior tenancy remains in lawful possession of the residential rental or real property, the owner may establish the initial rental rate not subject to the provisions in 1482, and subdivision A is only applicable to subsequent increases after the initial rent rate has been established. So let me say that in layman's language. In the current statute, 1482, it provides for vacancy decontrol, which means that if a tenant vacates the property and you want to rehabilitate the property and place it in a market rent-ready condition, you can establish a rent rate that is not subject to the requirements of 1482, and that you can establish that based on your view of market and what a tenant is willing to pay. In the same situation regarding the COVID-19 environment, there are significant efforts within the state of California to attack this provision and to, much like rent control that is in Los Angeles and other, like Berkeley and Santa Monica and San Francisco, to eliminate this provision under 1482. What that chance of the ability for 1480, for those legislative initiatives to be passed, I don't know. And I don't know whether or not the legislature or the governor is going to be willing to pass that type of provision. Now, it should be noted that the author of Prop 10, which has some new elements in it, has a new initiative that is going to be placed on the ballot, has already qualified for the November ballot. This is also another issue and an interesting dynamic that, do we know from a political perspective of some of these things like the split roll tax relating to commercial properties and increasing the real property taxes on commercial properties, non-residential, as well as the Prop 10 times 2, the new provision in November, whether those types of initiatives will be passed by the by the public. I don't know the answer to that. It will be an interesting social experiment. Because one of the things that I've experienced with a lot of residents is that they have generally been cooperative, have been recognizing that we're in this together, that we're all at the effect of this crisis, and that we need to work together in order to solve and be responsive to one another's needs. There is that small minority of tenant that is attempting to take advantage of the situation, but by and large, so far, they have been the minority. They have been the exception, not the rule. Now, how that translates into, in a presidential election, into the election and the ballot initiatives in November is anyone's guess. I mean, we're now in April. There's a lot of time between now and April and November to see how this is going to shake out. I'm not going to read all of these. Some of these exemptions are similar to the exemptions, I'll just let you read them, that we previously had gone over. And again, there are efforts to eliminate the vacancy decontrol provision, which in my opinion would be devastating for the multifamily industry, because if you have a rent cap, right now it's relatively, in my view, reasonable at 5% plus 1.8 plus a CPI. It's doable in this environment, but if you don't have the opportunity and the benefit of putting in new kitchens and new bathrooms and completely rehabilitating and repositioning the units, the apartment that is vacated, we may be in a position where that is going to negatively affect the value of the properties, and will have the potential of experiencing the downward trajectory of the quality of housing that has been experienced in rent control environments. There was a question, Shirley, that came through. Will these slides be provided or available to participants on the webinar? Is there a means by which they can contact you or you can send them out? You have to unmute, Shirley. Is the slide
We will actually have this we will have it posted on our website where they can actually go in and listen to the entire presentation again, and the slides will be there.
Oh, how scary. So they have to listen to me a second time? But
yeah, but they can fast forward you.
Yeah, but I guess the question is, Shirley, and I'm fine with it, is if they just wanted the slide presentation and they wanted to download it, could it be put in a PDF or could it be put in a document that they could just download?
Yes, if you like, I can email it to everyone after the presentation is over.
Why don't we do that? And any critiques or comments would be very, very much welcomed. Because I have a sense, and if you can give feedback back to Shirley when she sends this out to you, of whether or not you like the webinar and whether you would like to see particular topics covered, provide that feedback to Shirley, and we'll see what we can do. I was joking with my staff, and I don't think I said this to you. While I have a tremendous vision for technology and its application, in terms of the utilization of technology, I'm not that great. So I had my assistant along with Shirley work on elements of this. And this is my first webinar. I'm used to in-person teaching. But this is my first webinar utilizing Zoom. So I'm both the guinea pig, but so are you. So I do appreciate you putting up with me and going through this. So in the executive order from the, now this is more as it relates to COVID, I put this in, and one of the things that I wanted to draw your attention to, because this is really the basis of everything that has followed since then. So this was dated March 4th of 2020 on that first, and I'm not going, you can get this on the governor's website, but then I'm going to have you focus in on the next page where it says it is hereby ordered that the timeline limitation is set forth in the penal code subdivision concerning protections against residential evictions is hereby waived, and those protections shall be in effect through May 31, 2020. So that's important because the governor has indicated, depending on how things go, those protections may be extended through time. But then let me skip that next paragraph in paragraph 2 and really focus in on the next two. The basis for the eviction is non-payment of rent or a foreclosure arising out of a substantial decrease in household or business income, including but not limited to a substantial decrease in household income caused by layoffs or a reduction in the number of compensation hours of work, or a substantial decrease in business income caused by a substantial or reduction in operating hours or consumer demand, or a substantial out-of-pocket medical expense. So that's in the actual state of California governor's order. And then the second one is that the decrease in household or business income or the out-of-pocket medical expenses described in subparagraph was caused by COVID-19 pandemic or any local, state, or federal government response to COVID-19 and is documented. So in the second section, where the governor has ordered businesses closed, that fits within that definition. If as a result of businesses being required to close, and your tenants through their employment were either their employment was terminated or they were furloughed are examples of the COVID examples and situation, the crisis, that is having a direct impact on our tenants' ability to pay rent and provides for the prohibition against eviction. So then there was another question, how are landlords showing properties during COVID-19? So let me go into that. If you go into my website and you look up one of my properties, and it's not true of all of them, but you'll just have to search through. If you go on to RA and then Snyder, SNYDER.com, and you go into the sections for property availability, you'll see a number of our properties have video tours. So when we have a tenant that's interested, they can go onto our website and engage in a video tour of the property. We have had resident managers that have gone out with their phone and have done either a Zoom call or a Skype call, taking a prospective tenant through the unit, utilizing their phone. It works very effectively. Now, in our case, we have the ability for our tenants to do an electronic application. It can be approved electronically, and they have the ability to electronically sign a lease and sign where they're not even physically in the office of the property or otherwise. But video tours have been immensely successful. Now, we have made a decision in our company to maintain our offices open. And it has been very, very good. We have documents that support social distancing, and we are interacting with the public. If you don't know this, landlords and property management companies have been deemed by the governor as being an essential service provider. And so therefore we are not subjected when we're working to the stay-at-home order. And so I've been able to maintain my employment base to a large degree. And we've had our offices open in order to support our residents, be responsive to maintenance requests, and being able to rent apartments. And so far, so good. It's been an interesting process, but just the level of appreciation that I have for my employees is unbounded. I had an employee that came in my corporate office and said, you know, we've now been 5 weeks into this process, and I just want you to know how much I appreciate working for you, having my job, and recognizing all that we're all going through. But it's just nice to be able to have a job and to be able to work with a good company. And I think with most of us operating in that environment, I don't say that as a way of bragging, I'm saying that more out of kind of the golden rule of treating others as you would like to be treated if you were in the other position, that this situation really calls for that. And one of the things that we've attempted to do within the governor's order is to be very empathetic to our tenants. We have communicated to them with a letter. We've sent out a subsequent letter, not a 3-day notice if we've not received rent, in order to be proactive and communicate with them in order to do engage in that communication. Now, I'm not going to go over this last page of the governor's order, but what I am going to do is to go into a CAR document that was just put out that I wanted to bring to your attention. This is the CAR document that can be used for a notice to a tenant of ability to pay rent during the COVID pandemic. We use the basic format of this letter in our letter, and you can see what the language says. It's again, from the very beginning, is saying that the COVID-19 pandemic has had a great impact on all of us. So it's again creating that empathy. In response to federal, state, county, and city governments have taken actions to slow the spread of COVID-19. Among those actions have been the so-called stay at home, safe at home, shelter in place orders. One result of such orders is the loss of income for many of us. To address the economic impact of such orders, the federal, state governments and many county and city governments have issued orders protecting tenants who are unable to pay current rent due to COVID-19 related to job loss or substantial income loss. While there are differences in various orders, the common element is the requirement that tenants notify landlords if they have been unable to pay rent due to a COVID-19 related event. Additionally, the orders all provide that while rent may be abated for a certain amount of time, the rent is not forgiven and must be repaid once the order expires. Depending on the application order in place in your locality, the repayment time could be 2 months or more. So again, what this document is the communication that many of us sent out actually in the March period of time. Shirley is aware, but I'm just going to share with all of you that we had a scheduled for this presentation to be done in person, as many of you may know, at the North San Diego Association's offices, but because of the stay-at-home orders that were coming out and out of utmost caution, even though they were not in place at the time, we canceled the class. Then we were going to set it up to do this webinar at an earlier time, but because of some technology related issues, we decided to put it off until now. But the intent of this language is something that we put out in the March timeframe prior to the April rent. If you have not already done a notice to the tenant, I would recommend that you do it. Now, from my perspective, creating that more empathy and more personalized approach, I would take the essence of this communication, this is just my recommendation, and I would put this on your own letterhead. I would create your own personalized letter. One of the things that you're not seeing in this document is any demand. You're not seeing attached to a 3-day notice to pay rent or quit. You're not having any indication regarding late fees. There's nothing that is seeking to intimidate or press any residents relating to the payment of their rent. But there is the indication that while, and you notice in their document that there's no reference to evictions being in a moratorium condition. But there is an affirmation that the rent is due. Now, in my case, what we did is we accompanied our notice with a second page that provided a full list of resources and links. We provided this notice in an email form and not in a mailed document, so that we could provide the document that provided the links to the resources. Now, hopefully by now, the majority of the residents have already received their stimulus payment that came in on April 15th, and they've already started receiving their unemployment. That's all beneficial and all very positive. But I think having what I've seen in most successful companies in or out of the multifamily industry, is that by continuing a level of communication, positive communication has been very, very important. Now, to that end, when we sent this letter, we followed it up with a letter if we had not received hardship agreements, which I'll get into. Let's go on to the next page. So this is the coronavirus rent payment delay and repayment agreement from the California Association of Realtors. I'm not going to go through each element, but this is a document that if a tenant is indicating that, well, first of all, we initiated the original communication. If we didn't hear from them, then we're sending out another communication to them saying we have not received any communication, we've not received your rent. We're very interested in communicating with you and working something out relating to the current environment. If we have a tenant who comes back to us indicating that in section 2, that one of those aspects, or number 3, that relating to the proof is applicable, then what we're doing is sending this agreement to them. We're asking them to mark the appropriate box. We created our own document. I'm not using this one, but it's essentially the same. And then I'm engaging in with them with a plan to be able to mitigate the economic events that are going on. Most tenants have been amenable to this. I would say that those tenants that are experiencing hardships have paid some portion of their rent and have subsequently paid the balance of their rent pursuant to the agreement. Now, your guess is as good as mine as to whether or not moving forward in time, both for May and then June, if we're going to have to enter into similar agreements. I don't know the answer to that, but it may be. But having ongoing communication, in my case, as a property manager, my on-site managers are going out and actually making contact with the residents, maintaining the social distancing of 6 feet, but just as a way of communicating and engaging that dialogue, which I think is really, really important. And it was very good that the California Association of Realtors provided these 2 documents. And again, they're available through the California Association of Realtors. And on the first one going back, this one, I would recommend, as I mentioned before, that you do this as on a personalized letterhead. That's just me. On this one, I would use this document as it is, just by way of a recommendation. So with that, I think that gets us to the end of the, and this is just the final document or page of that second document regarding additional terms. So we've been going about an hour and a half. I'm amazed that I could talk that long without taking a breath, seemingly. But I would entertain any questions that anyone has as it relates to the presentation, or any questions that you have generally about some of the things that you're experiencing. So one of the questions that came in was, what would you do if they refused to sign the document? Again, I would just accept it. I'm not going to be concerned about that. My main concern is that I just want to be able to provide them with the document so that they've got it in hand. And my interest and issue, and I've had people refuse to sign it or to fill it out even, or to provide documentation. I've encouraged them to do so. I've indicated to them that, as they would expect and have every right for that expectation, for me to operate as the landlord in good faith, I think that they would do so as well. And again, going back to that golden rule of treating people as you would have them treat you if you were in the opposite position, I think the same applies, that by signing the document, by providing the background information, assists in that process of recognizing that there's a good faith effort being made. I've also told the residents that if their circumstances change, that I want them to communicate to us, so that, again, we can be empathetic, we can be connecting, and that we can have a situation or an ability to work together to address the situation. One thing that I've not addressed so far in this is that, and something that I've talked about in previous classes, is that when people are being negatively affected by a situation, they have a tendency of acting out, and they have a tendency of being angry. My experience is that a lot of that anger emanates from fear. So the more that you can connect with them, the more that you can work and go through that fear and be able to provide them with objective information so that they don't have to be fearful of being evicted from their apartment or their house, the better off that you're going to be. And one of the things, especially with the stay-at-home orders, is that people are feeling social isolation, they're feeling lonely, they're disconnected from family and friends. They may not have the capability of using technology to bridge that gap. And after 5 weeks, that stress is starting to show, and it shows in a variety of different ways. And so I would just urge you that, especially if a tenant is responding angrily to whatever the situation is, or is acting out, because I've had a couple of cases where tenants have been arrested because of their behavior in a property. I view that while that typically does happen, the possibility of it happening is increased in this current environment. And so I think we just all have to be aware of that, and we have to work through it. So with that, any additional questions that anybody would like to do through the chat function? Well, I'm not seeing any. Let's see, there's one more. Thanks, Rick. Oh, thank you, John. I appreciate the comment about the great job. Shirley will post this up on the website for the webinar. She also will send to the participants a PowerPoint presentation so that you have the details on the information. You can always reach out to me if you'd like. My email address is rick@rasnyder.com. And I'd be glad to help any of you. These are difficult times, and we can only get through it positively when we're working and helping and supporting one another. So with that, I want to thank all of you, and we'll look forward to doing it the next time, especially as things change. Shirley will be knocking on my door and saying, Rick, it's time for the next seminar or the webinar. So again, thank you all so much. Take care. Bye-bye. Any last comments, Shirley?
Thanks, Rick. No, thank you very much.
All right, take care. Bye-bye.
Bye-bye.